Today's Supreme Court ruling in the case of Mark Janis versus AFSCME is an historic victory for freedom of speech and freedom of affiliation for public sector employees. It is also an historic victory for taxpayers who, for too long, have borne the unfair high cost of the conflicts of interest inherent when government union leaders negotiate with but also support politicians.
This case is not anti-union. It's pro-worker. Unions can still represent workers and advocate for the things they believe in. The only thing that's changed is that workers will now have a choice, and that means that unions will have to earn workers' support instead of taking it for granted.
Well, there's not much more I can add to what's already been said. It is a very historic day. We now have 5 million public sector union members, or non-union members, that can make their own choice as to whether they want to be a part of that union. It will not affect the collective bargaining. Unions will have that continued right. It's just that the worker now has the ability to make his own decision or her decision. And that's why I brought this case. It's up to the worker to decide what they want for themselves, not some other larger entity. And it's not anything unusual than what we do in our daily lives as we go about our daily lives. And that's what is so important, and that's what the basis of this whole case is about.
Candidate of preserver choice without having those who control the union deciding for them. I believe Abuda had
This ruling is not anti-union. It is pro-worker and it is pro-taxpayer. That's what at the essence of this case. State employees in Illinois do an outstanding job. Union employees and non-union employees do an outstanding job. This case restores their rights to freedom of speech and freedom of affiliation. They can represent themselves if they choose. They can join a union and support that union if they choose. And the Supreme Court made the proper decision that in its very essence, everything that a government union does is political. Bargaining, work rules, all of that activity is political at its very core, and therefore forcing support of that financially is a violation of freedom of speech, political speech. That's at the essence of this case.
President Trump tweeted really quickly after the ruling came down that it was a big win and that now union workers do not have to support a candidate of preserver choice without